So unfortunately, the court system at the moment is very, very stretched. It's probably the worst I've seen since I've qualified as a solicitor. So particularly with Children Act applications, because resources such as CAFCAS they're really, really understaffed, so it's really difficult for them. The court therefore doesn't have the capacity to effectively manage the number of applications that they're getting in. And also, in addition to that, there's increasing numbers of litigants in person who are issuing applications in the court, which further creates pressure on the system. So it's really, really difficult. In terms of the challenges with these delays, the main one, of course, is the restrictions on contact and the time between hearing dates. At the minute, it can be typically anything up to 6 months between hearings, which is obviously really, really stressful and can really impact the progression of contact for certain parents. And understandably, the impact of that is the relationship with their child is suffering effectively. So it can be really, really challenging. So the best advice that I tend to give to clients in this situation is to look outside of the court arena and explore all methods of non-court dispute resolution. So they typically include mediation, child-inclusive mediation, early neutral evaluation, and arbitration for Children Act matters, all of which have different processes, but effectively they allow clients to take back some autonomy in the decision-making process to an extent with some of the routes. And just means that they have a little more control over the process and they're not sort of trapped within the court arena where there's lots of really, really restrictive timescales and unbelievable delays on top of the stress, of course, that comes with being involved in litigation. And we have a great team of mediators at Birketts who can assist with all matters in relation to children. And the rule change that occurred earlier this year effectively means that within the family court system now, parties have to effectively demonstrate why a form of NCDR isn't relevant to their situation, because courts are being really robust in making sure that court is very much a last resort option. And there's also could be consequences for parties who don't engage in NCDR, and therefore it's less common in Children Act matters, but the courts really are encouraging NCDR and sometimes are even refusing to hear matters before parties have adequately explored it if the court think it's relevant. So there's been a real change this year, I would say, in terms of the attitude towards litigation, and parties nowadays really do have to think twice before issuing.